Continuing chapter 19, deeds. What is a deed? It's a document used to transfer one's rights, title, or partial ownership interest in real property. Um, so the way that we transfer all of these things is by some sort of deed to convey that interest. Uh, a deed is a written instrument where an owner intentionally conveys all of those rights, like the air rights, mineral rights, their title, which is the ownership, or partial ownership, their interest in a parcel of real estate. The grantor is the one who sells or gives their rights or their ownership. Um, and a deed, I'm sorry, the grantor is the one that sells or gives the land. They're the one that are selling it or giving it away. The grantee is the one who's buying it or receiving that land, that title. Now, the grantor must sign the deed in order for it to be valid. We call it grant because that's what we're doing. We're granting our ownership to someone else. So the grantor is the one giving, the grantee is the one receiving. So the signature of the grantee, the buyer, is not required in order to make a deed valid, but the grantee must be named in the deed so that they can be readily identifiable. Now, deeds don't need to be dated because, once again, the transfer of ownership takes place upon delivery and acceptance of the deed itself. That's why it does not need to be signed or dated by the buyer. But the seller needs to sign. The grantor needs to sign. Deeds must be signed and dated, and signatures acknowledged to be genuine by all parties confirming their identities in front of a notary, judge, attorney, or other trusted person, like an elected official, a politician, before it can be recorded into the public records and added to the public records. Deeds are valid even if not recorded in the public record, though. It is, however, both the buyer and sellers, it's in both of their best interest to ensure that those deeds are recorded. Why is that? Why is it in their best interest to make sure that the deeds are recorded, that your interest is recorded in the public record? Well, um, so you bought the property now. The transfer of ownership takes place upon delivery and acceptance of the deed. You're now the owner because you possess the deed in your hand. That names you as the new owner, and it was signed by the old owner, right? It didn't need to be dated because the second you took it, you became the owner. So now you're in possession of the deed for the property, right? Um, what? Here, I'll give you a couple scenarios. What if that old owner gets sued? They're still listed in the public records as the owner of this piece of real estate. So because you don't record your own interests, it's still showing, reflecting as that it's a property owned by them. Um, Somebody can add a um, a lien to the property. If they get a judgment against that old owner in a lawsuit, they can put a lien on the property because they're listed as the owner. But if you record your interest right away, well, they're no longer listed as the owner. So any claims against that person can't be tried to collect on property that they are no longer listed as the owner. You got it? Or if you take it to the extreme, let's just say the seller wasn't the most moralistic person. Uh, you could have them, they sell you the property, they give you the deed, and then later on that day, they do the same thing with someone else. They write up another deed and sign it off and sell the property to someone else the same day. All right. Who's the owner? Well, now the race is on. Whoever can record their interest in the public records first, the other one's got to find them. All right. So that's more of an extreme circumstance. It's obvious fraud. They know they'll get caught. But I guess they're off flying off to some country that doesn't have extradition treaties. I don't know what kind of moron would try to stunt like that, but that is an obvious fraud crime, and it is a major crime for the amount of money we're talking about. But Yeah, nonetheless. There you go. So there's another reason. Here, I'll give you another one. Um, Somebody trips and falls on the property. Who are they suing? The person listed as the owner. That's still the old guy there. And so the old owner is the one that's going to want to make sure that you record your new interest too, because if somebody trips and falls on the property, they're going to sue him instead of you, even though you're the new owner now, because you never listed the fact that you're the new owner. So there's a bunch of reasons why you want to record your new ownership in the public records. Any questions?
No.
No.
So there's four types of deeds in New Jersey that are commonly used. We have a full covenant and warranty deed, a bargain and sale deed with covenants against Grantors Act, also known as covenants versus Grantors. They sometimes abbreviate that by writing CAG or CVG after the words bargain and sale deed. It'll say bargain and sale deed, CAG or CVG. This fourth one is totally different type of deed where it just says bargain and sale deed and nothing after it, when there's no covenants. What's a covenant? Anyone recall? It's a legal promise. They may be restrictive legal promises, but either way, it's a legal promise. A bargain and sale deed with covenants against Grantors Act is a legal promise. There's certain promises that the seller is making to the buyer if they buy their property. We're going to go over what those promises are in a moment, but let's first finish going over the types of deeds. And then we have a quit claim deed, which offers the least protection of any deed. You're just giving up any interest you may or may not have in the property. You're not even claiming that you have any interest. But just like a gold miner back in the gold mining days when they figured the claim is done and there's no more gold in the mine, they quit their claim. So now somebody else can take it up. So a deed is a written instrument by which an owner of real estate intentionally conveys their right, title, or interest in a parcel of real estate. The owner who sells or gives the land is referred to as the grantor, and the new owner who acquires title is called the grantee. And these are the legal promises, and you see how I wrote protections, and I wrote the arrow here. These ones at the top of the list are the ones that offer the most protection. The ones towards the bottom offer the least. And I wrote underneath where it says covenant, it's a legal promise. Let me know when you got all that down.
Got it. I think we highlighted this last time, but I already had this for some reason.
Yeah, I think earlier on in the book, we discussed these things. I think there was something else on this.
Oh, okay.
For some reason, we came here, and then you guys may have highlighted it. Yeah,
Got it.
but did everybody got it?
Yes.
Yeah.
Okay, so here we go. Here's just my screenshot. Makes it look a little bit neater, I guess. The grantor is the seller. The grantee is the buyer. You got the warranty deed, which also goes by general warranty deed or full covenant and warranty deed. Or full warranty deed. Then you have the bargain and sale CAG, that's Covenants Against Grantors Act. Could also be listed as CVG, Covenants versus Grantors. It's also known as a special warranty or a limited warranty deed. Because in this type of deed, the seller's saying, as long as I've owned the property, I haven't done nothing to encumber it while it was in my possession. As far as anybody that may have owned it before me, I can't guarantee that. I'm just guaranteeing the time that I own the property, I did nothing to encumber it. For anybody before me, do your own due diligence and get a title search and title insurance policy. And then we have a bargain and sale deed. It has no covenants, no legal promises that go with it, other than the fact that the person who's selling the property is saying that they have the legal right to sell it. They're not even claiming to be the owner. They just have the legal right to sell it. So a bargain and sale deed, also known as a straight bargain and sale deed, it's sometimes used in auctions and Sometimes they refer to it as a sheriff's deed. They'll put the word sheriff's deed on top of the bargain and sale deed. And then we have the quitclaim deed. A quitclaim deed, you don't even need to be the owner to sign it. You don't even need to claim that you have any interest in the property to sign it. By signing it, all you're doing is saying, I am quitting any claims of interest in that property without saying I have any interests in that property. Now, a quitclaim deed can just as effectively transfer the ownership as a full warranty deed can if the person who signs it has all the rights to ownership. It's just they're not making all the lofty promises as a warranty deed. So let's do some highlights here on the warranty deed. We're going to go over each one of these deeds really quick. So the warranty deed is also known as a general warranty or a full covenant and warranty deed. It provides the greatest protections of any deed. It comes with it the covenant of season. These are the promises, the covenants. Season, against encumbrances, quiet enjoyment, assurance, warranty forever, and then circle this down here, and then we'll move on to the next slide, which I'll go over this in a little more detail instead of me explaining it here on this slide. Now, you don't need to memorize all of these covenants. You just need to know that which type of deed offers the most legal promises and protections. Well, it's the full warranty deed, the full covenant and warranty deed, or also known as the general warranty deed. Let me know when you're good, and we can move to the next slide.
Good.
Okay, everybody else good too, or
Got it.
all right? All right, here we go. So, in a warranty deed, provides the greatest protection of any deed with these guarantees. The covenant of season. That means that the grantor warrants that they're the owner of the property and they have the right to convey the title to it. They're in possession of the property. They're seized of the land. The covenant against encumbrances. The grantor warrants that the property is free from any liens or encumbrances and will defend it in court. An encumbrance is a claim by another or a liability against real estate like taxes, judgments, liens, restrictive covenants, easements, licenses, etc., that may diminish the use or value of the property which the grantee, the buyer, was not previously made aware of. The covenant of quiet enjoyment. In a guarantee that the title is good against third parties who may step forward to claim that they have an ownership or some other interest in the property. So the covenant of quiet enjoyment is a guarantee that the title is good against third party claims against it and will defend it in court if anybody claims rights of ownership. And then we have the covenant of further assurance, that the grantor promises to obtain any documents, any instruments needed to make the title good, to produce the evidence in court, to defend it. And then the covenant of warranty forever. Ooh, this is lofty. It states that promises, those warranties, if they ever fail, the grantor will reimburse the grantee for any loss that they sustain. And here's the real biggie here. These covenants are not limited to the time for matters that occurred during the time that the owner, the seller, the grantee or grantor own the property. They extend back to all previous owners as well. How could you make a promise like that when you're selling real estate? Hey, I'm guaranteeing you that this property is good and clear from any liens or encumbrances during the time that I owned it, but also the time that anybody that ever owned it before me. That's a lofty claim to make. How do you know that sometime in the 17 or 1800s that there was no improper transfer of ownership. If somebody can ever produce evidence or documents that say that they were swindled out of the property or was stolen from them, or there was an improper transfer that occurred, then they could fight it in court. And if they win, you got to give up the property to them. What about the money that you spent to buy it? What about the money you put into it? What about the loan that you still owe money on? Your problem. So this is why title insurance is a good thing to get. You'll have somebody else do the search of the public records. The title insurance company is not going to give you insurance until they first do a title search. So they're going to do a pretty thorough search throughout history. They look back a minimum of 60 years, but they usually try to go back as far as they can. And that in the event that there is an issue later on that pops up that they did not discover, well, you're covered by the insurance that they give you. Now, there's two types of insurance, one for the buyer and one for the lender. You have to purchase both of them, or you not have to, you should purchase both of them. Your attorney should notify you that there are these two types of title insurance too. So one would pay off any balance on the existing loan. The other would reimburse the buyer for any money that they put in to buy this property up until now. And then we have the bargain and sale CAG or CVG type deed. It's a special or limited warranty deed because in this type of deed, it states that as long as I have owned this property, I have done nothing to encumber it while it was in my possession. I'm not guaranteeing the time that anybody owned it before me. For that, do your own title search and your own due diligence. Do your own inspections. So in this type of deed, the grantor is willing to warrant or guarantee that they have done nothing to encumber the property while they owned it. There's no guarantees are made for any previous owners that they haven't encumbered the property in some way. And the current owner states that they've done nothing to encumber the property while it was in their possession only. This is why it's sometimes referred to as a special or limited warranty deed. It's the most common type of deed that we use here in New Jersey with title insurance policy. So let's do those highlights. Or do you guys have them already too?
Got it.
I've got it.
Got it.
All right. In a bargain and sale deed, a straight bargain and sale deed, you see there's no other words after that. There's no CAG or CVG. This is a very different deed than a bargain and sale with covenants versus grantors. Keep that in mind, guys. Don't get lazy and mean to say bargain and sale CAG, and instead you just say, oh, bargain and sale, because that's an entirely different type of deed. So a bargain and sale deed, nothing after it. The seller only says that they have the right to convey the property. They're not making any other legal promises. There's no express warranties as to the quality of the title. And the grantee has little recourse, the buyer has little recourse if defects appear later. So caveat emptor, that's how you pronounce that term in Latin. It's not pronounced caveat emptor, it is caveat emptor. It means let the buyer beware. See, we're learning a little more Latin now. Caveat emptor, let the buyer beware. Do your own due diligence, do your own inspections if you want to find out if there's something possibly wrong with the ownership or the history of this property. Sorry, my fax machine's going off in my ear, and I'm not sure if you guys can hear it. Now, this type of deed is often used in a sheriff's sale, foreclosures, and tax sales. Okay. We got all the highlights there on 363.
Yep, we've
Yes.
got.
Yes. I'm good.
Okay, and the 363, continuing on to the bottom, onto the top of 364. Let's get those highlights. So this is on 363, this is on 364 at the top. A quitclaim deed provides the least amount of protection of any deed. It carries no covenants or warranties whatsoever. It doesn't even imply the person signing it has ownership or any rights or interest in the property. So why would you want to have anybody sign it? Well, because they could be the full rightful owner. But by signing it, they're not making any claims to that on paper. They're only saying, hey, I give up my rights or interests that I have in this property or may have in this property. It's most often used for simple transfers within a family, transfers of property during divorce settlements, or to clear up clouds on a title. You're like, yeah, I don't have any interest. I know I'm listed as the owner. You want me to sign something? Look, I'll sign a document that says I don't have any more interest in the property. I sold it to someone a while ago. Okay, so this is often used to clear up those breaks or gaps in the chain of title. Remember what a chain of title is? When you search the public record, if you could link one owner to the next, to the next, to the next, each owner would be a link in that chain. So if you could link one owner to the next, you got a chain of title. If you can't, it said there's a break or a gap in the chain. One of the links are missing. So how do we clear that up? Okay, well, you can clear it up by having somebody sign a quitclaim deed or have a judge produce all the documentation and title search information, everything to a judge, and they could try to make a decision there on it. So a quitclaim deed can transfer ownership just as effectively as a full warranty deed if the grantor, the seller, has good title, their interest to grant or sell it. Everybody got that?
Yes.
Yep.
So now let's look over, these are the requirements for any deed to be valid. Similar to a contract, right? You got to have legal capacity to sign, sound mind, legal age. The grantee has to be named with reasonable certainty in the deed so that they can be readily identifiable. There has to be some sort of a consideration. There has to be something of value given between the parties in that exchange, just like any contract, right? There has to be a granting clause. This is the heart of any deed. It explains what exactly is being sold or transferred. You know, it doesn't have to be the ownership of the property. It could be one's rights or interests, right? And following the granting clause is always another clause that we call the habendum clause. Now, on exams, sometimes they give stupid questions like, what do you call the clause that follows the granting clause in the deed? It begins with the words to have and to hold. Like you wouldn't even need to know what it does, you know, with that kind of a question, but that's often a question that you get on an exam like that. And the answer would be the habendum clause. I guess you could try to make it sound like have and to hold by saying the habendum clause, the haben to hold clause. Slow it down a little bit. The habendum clause is the haben to hold clause. It begins with the words to have and to hold written in the deed. So following the granting clause, it further explains anything stated that requires more details and clarification that was perhaps stated in the granting clause. It always begins with the words to have and to hold. The have been to hold clause. Got it? And then, of course, a legal description has to be in the deed. What exactly are we being transferred? What exactly is being transferred here? So a legal description must be included. What are those three legal descriptions we went over? Meets and bounds, government or rectangular survey, and a plat map recorded in the county where the land is located. So those are the three legal descriptions. Now, deeds do not have to be dated in order to be valid. They don't need to be signed by the buyer either, because the transfer of ownership takes place upon delivery and acceptance of the deed itself. Now, unless they try to record the deed in the public records, then everybody needs to sign it, and their signatures need to be acknowledged in front of a notary or other authorized public officer. And you should do that ASAP. So once again, here are those requirements we just went over, but at the end of it, highlight deeds do not need to be dated in order to be valid. You should also write in there or signed by the buyer unless they want to record it. Where are they recording it? In the public record, of course. Let me know, guys. Have that?
Yeah.
All right.
Good.
Everybody good? Okay. So here is the the anatomy of a deed. So these are things that we're going over on the next couple of pages. You're going over the parts of the deed. So first we're going to go over it all because I put it all on one slide here, and then we're going to go over each slide that goes over those things. We'll do the highlights of those items and make our notes in there. Okay, so let me first just go over it so you guys have an understanding of it, and then we'll go to it where you could write your notes in the book on it. Okay, so pay attention. The grantor. Who's the grantor? The seller.
So,
That's right there, right next to it. Grantor is the seller. The seller has to be at least 18 years of age or older to effectively convey, or the contract may be voidable. You must have legal capacity to sign or execute a deed. Now, for exam purposes and exam purposes only, can a minor ever sign the deed to transfer the ownership and it be valid?
Can a who, Victor?
A minor, someone under the age of 18?
No.
No, it will be voidable.
Oh, wait, can they sign? Can a minor what? Sign?
Can a minor ever sign a deed? It says, listen, the grantor has to be 18 years of age or older to effectively convey or to contract or the contract may be voidable. Must have legal capacity to sign and execute the deed and be of sound mind and legal age. So, can a minor is anyone ever under the age of 18? Can a minor ever sign a deed to transfer the ownership of real estate and it be valid?
No.
Remember, I told you, technically no longer in New Jersey, but for
For
exams,
exams, 17 years.
if they're married, if you're a
Yes.
married minor, then it would be valid.
Yeah.
You need to know that for exam, by the way. Now, grantee, the buyer must be named so that they can be identified with reasonable certainty. So they just need to be named in the deed. Then you have to have consideration. This is the full purchase prices, what the parties give or receive from each other in the exchange. So it's something of value exchanged between the parties. Legal tender, that's money or a mortgage loan. Fair exchange of goods or services like bartering. And love and affection, in which case it would be a gift to somebody that you have love and affection for, right? So a consideration of $1 or love and affection must be accompanied by some sort of an affidavit, which is a sworn statement explaining the transaction is, for example, a gift. What's an affidavit? It's a sworn statement. The granting clause is the heart of any deed. It explains the type of deed that's being used. What is exactly being transferred? Title, rights, interest, how the new owners are taking ownership, whether it's tenancy in severalty, that's sole ownership, tenancy in common, joint tenancy, or tenancy by the entirety. Then it's followed up by the habendum clause. It begins with the words to have and to hold. Its provisions must match those and not contradict those in the granting clause, and specifies things that need further clarification, like what the percentage of ownership is. Because if one person paid 75%, put up 75% of the cash to buy this property and the other only put up 25, if you don't specify that one person is 75% owner, the other one's 25, it's 50-50. So you would want to specify that here in the habendum clause, like the percentage of ownership. Or if there's several owners, that don't have equal shares, or naming a remainder man if it's a life estate. So anytime something needs a little further clarification that was stated in the granting clause, you would put that here in the habendum clause. Now, when I say you, it's not going to be you guys. You guys don't fill out deeds. This is attorneys. They do this stuff. But we need to understand the anatomy of deeds and how they work. You go in for a listing, you want to ask that owner if they have a copy of their original deed when they bought the property so you can look it over and see who all the listed owners were. And if you see there's only two of them, like a husband and wife, but yet there was a third owner listed, you may want to ask who that was. Could have been a parent that maybe passed away or something, right? And they, whoa, we need them to sign too. If they're passed away, well, who did they leave their rights to? We're going to need those people or person to sign if they didn't leave it to you.
Victor, actually, I was going to ask you about that in terms of the grantor. What if they were left property and they're under the age of 17 and they're not married?
Okay.
Are they allowed to, this is a reference to your question earlier, are they allowed to sell?
Not on their own. They have a parent, a legal guardian, right?
Well, say their parents left it to them. Their parents pass away, left it to them. They're not married. They're a kid.
So what, are they just walking the street or are they living with somebody? Do they have a legal guardian now?
So the legal guardian has to be involved?
Yes.
Okay.
A description of the real estate. What are the three legal descriptions of land? We have the meets and bounds system, which we use in New Jersey and the 13 original states. We have the rectangular and government survey, which is not used in the 13 original states. It's used in Western states. And we have a plat map, which is a map of a subdivision, right? Although lot and block numbers and addresses are helpful in describing real property, they're not considered legal descriptions. Hell, did you know that the post office can change your address? Did you guys know that? Little useless information to help you out there. I've actually had listings before on 2 occasions where the post office changed the address of the property I was selling. Somebody built a property in between, and instead of just putting in a 536B address, they shifted the addresses of all the properties on that block all the way down. Everybody's address changed on the block. Figured there'd be a simpler way to do that. Just, hey, if it was lot number, where there was, it's not a lot that was being split up, but there was a vacant lot there that never had a house built on it. Now they build a house on it, but yet you got all the consecutive numbers assigned. The post office may shift them all over. Instead of taking your address and putting a 536 house number, they'll put 536B, but they're not going to do that to somebody's house. If it's a different house, it'd be a different thing if you have a multi-unit house. You could have 536A, 536B, or even if you subdivided your property. But when you're adding another house where there previously wasn't one on a lot in between 2 houses, sometimes the post office will just shift the addresses down the street. What a major inconvenience, right? You've been living in that house for years. It's been your address all your life that you've been living there. Then all of a sudden they change your address on you, but you didn't move. Have you guys ever heard of such a thing? It happens. So that's for this reason, the address of a property is not a sufficient legal description. If the post office can change it, okay. So what? Now all the owners changed on all the deeds because they only listed the address as the legal description. That's why addresses are not considered legal descriptions. All right. So exceptions and reservations. Any reservation in deeds by private parties are called restrictive covenants, and they can be added, and the type of estate that has restrictive covenants added to the deeds are known as fee determinable, defeasible, or conditional fee estate. It's all the same type of estate and land that ownership forever based on a restriction. We've seen those types of ownerships described on page 104. So fee determinable, defeasible, or conditional fee estate. It's all the same estate and land there. It is ownership forever based on a restriction. Those restrictions can only be placed in deeds by private parties, and restrictions placed in deeds by private parties are called restrictive covenants. And then signature of the grantor, the seller, must be signed by the seller. The buyer's signature is not required in order for a deed to be valid. It's just that they cannot record it in the public records until they do sign, and then their signatures should be notarized or witnessed, by an attorney, judge, notary, or other trusted public official, an elected politician. So, your deed is still valid even if you don't sign it, but if you can't record it in the public record until you do. That's it. And then the acknowledgement that provides evidence that those signatures were genuine, once again, to prevent forgery, usually witnessed by notary, judge, attorney, or elected official. All right. Anybody need a snap picture of this that had not yet? You may want to.
Got it.
I got everything there conveniently.
I'll take a quick photo. 1 second.
Yeah. I mean, it's a convenient note, notes all in one place here.
Got it.
Okay. So the requirements to convey property, you have to have those exceptions and reservations that affect the title, the signature of the grantor, an acknowledgement made before a notary public, judge, attorney, or other official. It provides evidence that the signature is genuine in order to prevent forgeries. You have to have delivery and acceptance. Implied delivery is possible. Implied delivery is possible. Transfer of ownership takes place upon delivery and acceptance of the deed itself. Deeds do not need to be dated because transfer takes place upon delivery and acceptance. So someone has to deliver you the deed, someone else has to accept it. Now, implied delivery and acceptance is possible. I'll give you one example. There was a Motown diva. Don't ask me her name. I can't remember it for the life of me now. But I remember reading about the story. It became a lawsuit. There was a lawsuit over it. There was this was in New Jersey. There was a old Motown diva who was selling her estate, her real estate, and they were doing this all on the phone between the attorneys of both sides and the seller and the buyer. Um, and the attorney sent over the paperwork to the seller to sign. So she signs the paperwork, and she's to FedEx it. They're talking on the phone in conference calls. They're going to be expecting this. The guy transfers the funds to her bank account. She's FedExing over the paperwork, the deed, and whatever required paperwork that she needed to sign still. She's over to FedEx it out. So somewhere between the time she hung up on the phone and going to the FedEx to drop off that document, she dropped dead. So now all of her kids are fighting over her estate. They got all that money in the bank account, and they want to keep the house too. No, 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 my friend. Some of that money that was wired to her, that belongs to the person who was purchasing the property, right? You're either going to give them their money back, or they're going to take your house. Now, did a transfer of ownership take place? I would submit, yes, it did. Because all of their intentions were in words. They were speaking on phone and conference calls. She actually signed the document, which was still in that FedEx envelope, but the kids wanted to keep the house because they're like, oh, well, the transfer of ownership didn't take place because she never delivered it. Okay, well, then give them the money back. You can't keep the money and the house. That money is in the account because you wired it over to her. So that created a little bit of an issue. This is why usually we put those funds in escrow accounts. I don't know why it was wired directly to her. I don't know what the deal was with that, but it was an interesting case, and it caused a headache nonetheless, I'm sure, for that buyer anyway. So to be valid, all deeds must contain an acknowledgement of the grantor's receipt of something. That's consideration. Something of value that's given and received from between the parties. Then that affidavit is a sworn statement. Let me know when you have both of these things highlighted, will you?
Got it.
Got it.
All right, everybody good? Everybody got it?
Got it.
Awesome. All right. Then the habendum clause. Further clarify. Can you guys read my handwriting here, or is that horrible?
No, we can read it.
Okay. Well, if it wasn't, I would just type it. I would just type it in there so that you could read that better. It just says further clarifies terms stated in the granting clause, like percentage of ownership or naming a remainder man. Then here I just wrote legal description. See page 354 for that. Exceptions and reservations placed in deeds are known as restrictive covenants. We went over that chapter 6, page 104. I'll give you guys a minute to finish that.
Got it.
Victor, what is that last word up top? Remainder man?
Remainder man.
Okay, one word?
Yep, one word. Remainder man.
Thanks. Got it.
And the remainder man, you don't recall, is a third party named in an instrument to be a beneficiary. We went over those in chapter 6. Again, just let me know when everybody's got it.
I'm good.
Anybody still writing?
We're good.
Okay.
I'm good. Yeah.
You're still writing?
No, I'm good.
Okay. Okay. All right. And then we have to have the signature of the grantor. All the sellers need to sign the deed in order for it to be valid. Grantor's signature may be signed by an attorney in fact under a power of attorney. Remember that? You could have somebody sign documents on your behalf if you're signing as a power of an attorney. This is an interesting little thing, so this is why I'm reading this. So an attorney in fact is any person who's been given the power of attorney to execute or sign legal instruments for the grantor. In such cases, usually it's necessary for the power of attorney to be recorded in the county where the property is located, because the power of attorney terminates on the death of the person granting that authority. So evidence must be submitted that the grantor is alive at the time the attorney in fact signs the deed. Ooh, isn't that interesting? Because how do we transfer the ownership of real estate while we're alive? How do we transfer the ownership of real estate while we're alive? Please tell me you got this. While you're alive, how do you transfer the ownership? We've only been going over it all morning.
Deed.
Indeed.
Some sort of a deed to convey that interest. And how do we transfer the ownership of the real estate after you die?
When
Yeah, your last will and testament. Correct. So when does a will take effect? Only after
you die.
you die. So before then, it's transferred by deed. So if you gave someone else the authority to sign documents on your behalf, that's only good for as long as you're alive. So if they're signing those documents, is it possible that they could sign a document after you died? So, yeah. So because of that, we need to ensure that when they sign that document, you were still alive. Otherwise, the transfer of ownership takes place according to your will. So, how do we prove that you were alive when they signed the document? Well, appear before a notary after the day that the documents were signed. That'd be enough to prove you were alive, right? So you could just sign, go appear before a notary. A notary would just say this person had produced, identification and presented themselves before me on this date. Boom, you're alive. So then you record that document in the deed along with that power of attorney and the new deeds, etc. So now if anybody in the future ever does a search of the public records, they could be like, well, who's this person and why did they sign the deed? Oh, they were given a power of attorney. Okay, was the seller still alive? Oh, yep, here's an affidavit there from the notary that says they appeared before them. Yep, okay, they're alive. So to prove the person was alive at the time the attorney in fact signed a document on their behalf, they would need to appear before a notary public, produce their ID, and the notary will confirm they appeared before them on that day. The document would then be added to the public records for recording with the deed and the power of attorney. Boom. You're probably not going to get a scenario like that on exams, but this is something that you should know about. An acknowledgement. It's a declaration made by a person who's signing a document before a notary public or other authorized public officer. Hold on a second. Yeah. The acknowledgement usually states that the person signing the deed or other document is either known by that officer or they produce their sufficient identification to prove who they are before they sign any legal documents. The acknowledgement provides evidence that the signature is genuine, and that is to prevent forgery. Now, although an acknowledgement is usually made before a notary public, it could also be taken by a judge, attorney, or other qualified person. This is all on page 366 under acknowledgement. Although an acknowledgement is not required to make a deed valid, in New Jersey, all deeds, mortgages, and similar documents must be acknowledged before they can be recorded. And each document must be signed before a notary public or other authorized public official, before a witness who must attest to the validity of the signatures, the grantor's signature. The signature of the witness would then be acknowledged before the authorized public official. From a purely practical point of view, A deed that is not acknowledged is not satisfactory instrument. Although an unrecorded deed is still valid between the grantor and the grantee, it does not protect against claims by subsequent innocent purchasers. So remember, I told you that little story about how, if I am an unscrupulous seller and I sell you the property and I sign a deed over to you today, and then later on in the afternoon I sign the same deed over to someone else. Okay, that's what they're explaining there. That could happen in that case. So to help assure good title, a grantee should always require acknowledgement of the grantor's signature on the deed so that it may be recorded. All right, you guys have all this?
Yes.
Yes.
Yep.
So before the transfer of title by conveyance can take effect, delivery and acceptance must exist. There must be an actual delivery of the deed by the grantor and either actual or implied acceptance by the grantee. Title said to pass when a deed is delivered. So highlight delivery and acceptance and then put a little arrow there and then highlight title said to pass when a deed is delivered. So the effective date of the transfer of title from the grantor is the date of delivery of the deed itself. Now here's a neat little story. You guys remember Schoolhouse Rock? Anybody here? If you grew up in the United States, you probably remember there used to be these PSAs, public service announcement commercials after you get out of school. They'd be learning for education commercials for children. Things that teach you everything from English language to politics, conjunction, junction, what's your function? You guys remember that? What is a bill? They show you how bills get passed in Congress. Well, in that same cheesy, cartoonish characters and those same cheesy, cartoonish voices, I'm going to read to you a little story that explains to you how the transfer of ownership took place in the Middle Ages when few people were literate and could read or write. Think about that for a second. How do you transfer the ownership of real estate if you don't know how to read or write? If you're illiterate? Well, here, close your eyes and just listen to my story as I read it to you. In England, during the Middle Ages, when few people were literate, transfer of title occurred in the following manner. The seller took the buyer to the field in question, and they walked the boundaries. This was known as the beating of the bounds. Then the seller reached down, took up a clod of the earth that represented the whole field, and they handed it to the buyer. At the moment that the buyer seized that clod, they became the owner of the land. Today, a document is used instead of a clod of earth, but title still said to transfer at the moment of delivery and acceptance, and the owner still said to be seized of the property. So the word season still denotes ownership and control. Can you picture that? People walking around, the seller walking the buyer around the boundaries of the property line, saying, here's the property line, it starts here, goes there, goes there, goes there. They picked up a piece of the dirt, handed it to the guy, and they're like, there you go, you're now the owner, you seized the land. How do you prove that later on? What do? You keep that piece of dirt in a bowl somewhere? Look, I got the dirt for the land, I'm the owner, hey. That wasn't exactly a bright way to do it either, right? Somebody else can come by and say, oh, look, I got dirt too. Somebody gave it to me. Yeah. But that's why we use documents today. So corporations can convey real estate with a proper resolution passed by a board of directors because they're the ones that make all the major decisions on behalf of a corporation. They generally require a resolution authorizing the sale be secured from the stockholders when a substantial amount of the real estate owned by that corporation is being conveyed. Only then do the stockholders put any input into it. Otherwise, it's the board of directors that make all those decisions solely on their own on behalf of the corporation and the stockholders. So only an authorized officer can sign deeds. So that corporation, they're not going to have, who's going to sign the deed? What, everybody on the board of directors? No, they're going to usually assign one person to be the authorized signatory for the legal documents to transfer those ownership. So that's why we're going to highlight a corporation can convey real estate only upon a proper resolution passed by its board of directors. So they voted on it, they made a decision to sell. Boom. So that's what we probably need to know that one for exams. However, if all or a substantial portion of the real estate of that corporation is being sold, well, then they're going to need to get a resolution from their stockholders as well. Deeds to real estate can be signed only by an authorized officer. So they'll vote on who that authorized officer is, and they'll give them a document that shows that they are the authorized signatory. And there's a little notation here as well. The corporate seal need not be affixed to the conveyance unless there's an acknowledgement that mentions that the seal has to be. Everybody got that?
Yes.
Got it.
Then that's it for this chapter. Let's do the key terms to review, and chapter 19 will then be done. So, one who receives property through a deed. Key terms 1. One who receives property through a deed. What do we call that? The person that receives the property.
Grantee.
The grantee, correct. So 9 is A. A deed implying that the grantor owns the property, but nothing more. They're just saying, I have the legal right to sell this property. Not guaranteeing you the quality of the title or anything.
Sale deed, bargain and sale deed.
A straight bargain and sale deed, correct. 2 is B. Actions that actually transfer the title. The actions that actually transfer the title. What do we call that?
Delivery and
Delivery and
acceptance.
acceptance.
Delivery and acceptance. 8 is C. A clause in a deed that makes the transfer.
Granting clause.
The granting clause. Ooh, 10 is D. Legal promise.
Covenant.
Convenient.
Covenants. A covenant is a legal promise. 5 is E. A document used to transfer title to a parcel of real property.
Deed.
Deed.
Deed. 7 is F. Mean sea level at New York Harbor, also local zero elevation point. What do we call the measurement of elevation?
Datum.
The datum. The datum, the datum. 6 is G, correct. A deed stating the grantor is not encumbered, has not encumbered the property. A deed stating the grantor, the seller, has not encumbered the property.
Bargain and sale, CAG.
The bargain and sale CAG type deed, also known as CVG, special warranty or limited warranty deed. Yes. 3 is H. I think on exams they refer to it as Covenants Against Grantors Act or CAG. Correct. So 3 was H. A declaration to a notary or other official to prevent forgeries.
Acknowledgement.
An acknowledgement. 1 is I. A marker placed by the U.S. Geological Survey stating elevation. What do we call that marker?
Benchmark.
A benchmark. 4 is J. All right. Let's do key terms 2. Spot at which the meets and bounds description, legal description of land begins and ends.
Point of beginning.
The point of beginning. 6 is A. A fixed natural or man-made object identifying boundaries in meets and bounds descriptions. You could also pay surveyors to put these at the
Yeah,
corners of the property.
monuments.
Monuments. 5 is B. One who transfers title by signing a deed.
Grantor.
The
Grantor.
grantor. 1 is C. Description sufficient to identify a parcel that's accepted by a court of law.
Legal description.
3 is D. The legal description. To have and to hold clause explaining ownership explains ownership being transferred.
Habenda.
Clause.
The habendum clause. 2 is E. Geez, they didn't even finish the definition there. They just wrote to have and to hold clause that explains ownership being, I guess, being transferred. So 2 is E. The have and to hold clause, or the habendum clause. Now, deed providing grantee with the most protection.
Warranty deed.
Warranty deed.
Warrant.
9 is F. Warranty deed also goes by general warranty deed or full covenant and warranty deed. So that was 9 is F. System for land description used in Western states, not the 13 original colonies.
Rectangular survey.
The rectangular or government survey system. 8 is G. Correct. A deed releasing any interest grantor may have without claiming season.
Quick claim deed.
They're just quitting their claim. It's a quick claim deed. 7 is H. A description using boundaries and direction. We use this one in New Jersey.
Meets and bounds.
Bounds.
The meets and bounds, the meters and boundaries. Correct. 4 is I. And that concludes chapter 19.